is Michael Robinson. I'm a litigation partner at Turner Hopkins. In this current economic environment, it's very common for businesses to be facing financial difficulties. The most important thing when you receive a statutory demand, even if you don't owe the money or dispute the debt, is to take very urgent steps and receive advice. The timeframes are very tight. It's a very common situation for a company to fail to pay its debts, particularly in the current difficult economic times. If you have issued an invoice to a company and it hasn't been paid within a reasonable period of time, there are several options available to you. The first and most straightforward, which is available in a case where the debt is not the subject of any dispute, is to issue a statutory demand against the company. That is a very simple document which is served on the registered office of the debtor company. If the debtor company doesn't take steps to address the debt or deal with the statutory demand within 10 working days of its service, you're in a position then to commence liquidation proceedings against the company. It's important to be aware that statutory demand proceedings are not available where a defence has been raised or there is a genuine dispute. If that is the case, then the options available are limited to civil proceedings in the District Court for debts below $350,000, or alternatively in the High Court. If the customer is a company, one of the most straightforward things that can be done is to require a director or other person involved in the company to provide a personal guarantee, which would mean they would become liable for the debt if the company doesn't make payment. There are a number of other options available as well. That includes obtaining some security, possibly by way of a caveat or mortgage over property owned by the customer, or obtaining security in the form of a GSA over the assets of the company. This is an area in which it is critically important to obtain good legal advice and assistance in preparing the documents upon which you'll be relying. Turner Hopkins is able to provide expert assistance in preparing guarantees and security documents to ensure that you are better protected in the case of an account that remains outstanding and unpaid. It's not at all unusual for a partner to leave all their assets, often their home, but also investments and other assets, to their spouse or de facto partner. That spouse or de facto partner might not be the parent of the deceased person's children. In cases such as that, the children often feel very let down and aggrieved. Our advice at Turner Hopkins is always for people to envisage these situations before they arise, for parents to talk with their partners and their children about what they intend to happen with their assets after they pass. It's important for people to be aware that there are very strict time frames that apply to such claims. Essentially, a claim needs to be at least registered and possibly advanced within 6 months of the date of probate being granted. That time goes by very fast, so it's very important for people to receive competent legal advice as soon as possible if they find themselves in such situations.